Avoiding the Financial Trap of Long-Term Care Costs. My name is Lynn St. Louis. I am an estate planning and elder law attorney at ELG Estate Planning. We have offices in Spokane, Tri-Cities, and in Seattle. What we're going to be talking about today is Washington law on estate planning, Washington law on Medicaid, and give you information so that you have a better understanding of what steps you can take to avoid the trap of financial long-term care costs. And what I really mean by that is that oftentimes people don't know that there are steps that they can take to avoid spending all of their own money on long-term care costs. Long-term care costs are a benefit that are paid under the Medicaid program, but only if you qualify. We're talking today about Washington law. So if you are in a different state, you might find this information helpful, but your laws in your state will be different. I encourage you to reach out to an elder law attorney in your state to find out what your state's rules are and how you can avoid the financial trap of long-term care costs in your state. If you don't know how to find an elder law attorney in your state, there is a website from the National Academy of Elder Law Attorneys, which is naela.org. And there's a find an attorney function on that website. NAELA is the National Organization for Elder Law Attorneys. So take a look there if you are in a different state. Now, for Washingtonians who are listening, I will be sharing my screen today to because Medicaid and estate planning is fairly complicated. So I'm going to try to assist in the storytelling with having some slides to share with you. I'm going to go ahead and start by sharing my screen. As you can see, what we're talking about today is avoiding the financial trap of long-term care costs. And what I mean by that is, how can you not end up spending down everything you have because you didn't know any better? Well, you're going to know better because we are going to be talking about that today. So this is a picture of me taken a little while ago, as I'm sure you can tell. Let's move on to what we're talking about. So anytime we're talking about how do you avoid spending all your money on long-term care costs, and you're listening to an estate planning and elder law attorney, we're going to start with talking about the basics of estate planning. So there are a lot of ways to pay for your long-term care costs. Well, maybe not a lot of ways. Here, let me go over the standard ways, then we'll get into the estate planning documents. The standard ways to pay are through your own income, your own savings. If you have a long-term care insurance policy or some insurance policy that pays a long-term care insurance benefit, that's fantastic. That will, of course, provide funds so that you are not spending all of your own money on your long-term care costs or on the long-term care of a family member. However, I can tell you that for most people, certainly in our experience, that people tend to not realize that there are steps that they can take aside from buying long-term care insurance where they can avoid that trap of spending out all their money. So we need to start with basics. Estate planning basics, you've probably heard this before. We need to make sure that you have your living documents. That's your durable power of attorney for finances, your durable power of attorney for healthcare, your living will, which is also called an advance directive or a healthcare directive. They mean the same thing in the state of Washington. And then your documents that say where your assets go when you die. That would be your will or your revocable living trusts. Now, whenever you hear the term trust, it sometimes is confusing because trust can mean so many things. one of the things I want to point out is that within a will or within a revocable living trust, you can create other trusts. For the creation of these other trusts within these documents, it's typically done when somebody passes away. So a revocable living trust is intended to avoid a probate. A will requires a probate. We'll talk about that. Within your will or your revocable living trust, you can have these trusts that are created on your death. And if you have a will and the right kind of will and the right kind of trust within it, you can protect against long-term care costs. In addition to basics of estate planning, basic estate planning documents, I want you to keep in mind that those documents don't cover all your assets. Certain assets are not going to be passed under your will or your revocable living trust. You can have an account that you have set up, joint ownership, joint tenancy with right of survivorship. On your death, that asset goes to the joint owner. It doesn't go under your will. It doesn't go under your trust. So keep that in mind. Certain assets you're familiar with, your life insurance, your 401k, your IRA, those all have beneficiary designations on those. And a bank account can have something called a pay on death as well. What that means is that that asset has direction such that on your passing, it goes where you said it would go. So if you have, let's say you're a single person, you want your assets to pay to your 2 kids equally, you can say that. You put a beneficiary designation on that particular asset, and it passes outside of probate, outside of your revocable living trust. And by the way, retirement accounts typically are not put into a revocable living trust. So it's really important that you understand that just because you have a will or just because you have a revocable living trust doesn't mean you stop there. You think about, what are all my assets? If you're trying to do this on your own, you might not know what to do, how to direct them. You might seek out the services of an estate planning attorney. Even if you don't, I just want you to know that all your assets need to be coordinated with your will, with your revocable living trust. There's other estate planning documents called a transfer on death deed. Like take that single person, for example. If she wanted her assets to go to her home, rather, to go to her 2 kids, she can put on a deed. She records during her lifetime, says, on my death, my home goes to my 2 kids equally. And that avoids a probate, that avoids putting the asset in a revocable living trust. There's also things called community property agreements, at least in the state of Washington. Outside of the state of Washington, people refer to a community property agreement as a Washington will. I never think of it that way, but a community property agreement can say on my death, everything goes to my spouse, no need for probate, no need for a revocable living trust. A community property agreement can also say, hey, everything we have is community, but I reserve the right that it go where I say it goes through my will, for example. So these are really important concepts. Let me point out that community property agreement, oftentimes people just sign it and they don't even realize what it is. So it's really important to understand that it has a profound effect on your estate plan. It means an inheritance you get from your parents is no longer your separate property, but community property. So just be aware that just because a document looks innocuous, it may only be 1 page, maybe 2 pages, it can have a really significant effect. So those are basics of estate planning. I went through them very quickly. We will circle back to them after I've talked a bit about long-term care costs. So when we're talking about paying for long-term care costs, it is undeniably a major concern for people who are older, for people who are disabled, maybe for younger folks who have experienced long-term care of their parents or of their grandparents. You know, long-term care can be a very short situation, 6 months, for example, or it can be a lot longer. In my personal situation with my mom and dad, their long-term care went for 14 years all told. So it was definitely a major long-term care event. It's probably one of the reasons it is that I am an elder law attorney so that I can help other families understand their options and understand the rules. As you can see, from this slide, 7 in 10 people will need some long-term care. Question is how much? And how do you pay for it? In Washington, we have, you can privately pay, you can have long-term care insurance. There's a new program, it's a payroll deduction. If you're receiving a paycheck, you know that you pay for the Washington CARES Act, unless you have an exemption for long-term care insurance you already have. Sometimes veterans benefits will apply depending on the vet situation and whether they served in wartime, what their resources and income is. Medicare. I point this out because Medicare, a lot of people think that Medicare pays for long-term care. It does not. It pays for up to 100 days in a skilled nursing rehab facility. That's why it's confusing. Maybe somebody goes into the hospital, they broke their hip, they go to rehab at the skilled nursing facility, and then Medicare is paying. And then they go home, and so they never realize that Medicare doesn't pay in the event that after that rehab period, they needed to go to a care facility. At that point, Medicare stops, and then what pays? Medicaid is the primary pay source for people who are in skilled nursing. But skilled nursing isn't the only type of long-term care facility. There are others. But basically, everybody knows this is long-term care is expensive. $150,000 a year easily for long-term care. So let's talk about Medicaid. And there's been a lot of talk about Medicaid in the news lately. I am not talking about Medicaid health insurance per se, or Medicaid what I'm talking about today is Medicaid that pays for long-term care support services. Medicaid is a state program and it is a federally funded program. Every state has its own version of Medicaid long-term care benefits. What we have in Washington is going to be different than Oregon, different than California, etc. That's why earlier on I said make sure if you want to know about Medicaid in your state, see an elder law attorney with Medicaid expertise in your state. In the state of Washington, we call the Medicaid program the Washington Apple Health Program. It covers care in facilities, nursing homes, assisted living, adult family homes, and it also covers care at your own home. In order to be eligible for Medicaid, you need to be medically eligible, meet an income test, and meet a resource test. Now, the medical eligibility test is not that difficult. If you need care, you need care. With activities of daily living to activities of daily living, or perhaps the person is very healthy, but they have a cognitive impairment, such they need help because of that with medication management and for their own safety. Typically, the medical eligibility requirement is not tough to meet because that person needs long-term care. This assessment is done when we apply for Medicaid by a DSHS social worker. They do a care assessment to find out whether the person actually needs help. Then we get into what is more interesting, which is the financial eligibility. And we're going to talk about income first. In a skilled nursing facility, basically the person who needs the care, their income must be less such that than the private pay rate. In other words, they don't have enough money to pay for their care. Let's say their income is really high, $20,000 a month, and the facility's care cost is $15,000 a month. They don't meet the test. They don't need Medicaid. It's kind of a no-brainer there. One of the things I do want to point out is that when the state under the Medicaid program looks at whether what their income is, they don't look at the spouse's income. let's say the well spouse has $20,000 in income and the ill spouse only has 5,000. Well, they meet the income test. You might say, then why is this couple looking at Medicaid? And I would ask the same question, because together they do have enough money, more than enough money to pay for the skilled nursing. There is another program that has a different income test. It's called the Community First Choice Income. It is a different income standard. Currently in 2025, the federal benefit rate is $967 per month. For somebody to qualify for in-home care under the, I'll call it the CFC program, they can't have income more than $967 a month, so a very low standard. For people who need not skilled nursing and not at-home care, but they're going to be at an assisted living, memory care, adult family home, their income can be 3 times the federal benefit rate, so $2,901. There's another program under the Medicaid program that pays for long-term care in facilities and at home. It's called the Community Options Program Entry System. Do not know how that acronym came up, but it's called the COPS. Call it the COPS program. For that program, it's the same income standard to be categorically needy as what I just explained for the CFC program, but it's not limited to that. In fact, this is not a typo. The maximum gross income for somebody to qualify for the COPS program is $13,542 a month. So a very high income allowance or standard. So somebody that has $10,000 a month will qualify for COPS from an income perspective. Somebody that has $13,542 gross income will qualify for the COPS program based on their income standard. So usually income isn't a barrier. What's the next barrier? The resources, the resource allowance. So this is where it is true that Medicaid can be considered an impoverishment program for a single person, because they can only have $2,000 in countable resources. We'll talk about what's not countable, what's exempt. $2,000, we'll all agree, is an impoverishment standard. There, and by the way, that has been the same standard since 1989. There is, interestingly, no resource limit if somebody is under the age of 65 and in a nursing home and they haven't been on Medicare. So that's something that can be useful depending on the person's situation. Now, we have a policy in the state of Washington against spousal impoverishment. So that, because of that, the state allows the community spouse, the well spouse, the person who's not going to be applying for Medicaid, to keep money so that they are not impoverished. The amount that somebody can keep, the well spouse, is between $68,301 up to $157,920. The COPS program is the program that has the smaller resource allowance of $68,301. If the spouse that is sick is in the skilled nursing facility, that's when the possibility of this well spouse keeping more money goes up to $157,920. In the state of Washington, we have an interesting way to figure out how much that can be kept for skilled nursing. Basically, for the couple, for the well spouse to be able to keep $157,920, they had to have twice that amount in countable resources when the ill spouse became institutionalized, went into the hospital, and then was expected to stay in the hospital after that. So none of this is commonsensical. It's all a bunch of numbers based on what the rules are in the Medicaid program. If you research this in Google or artificial intelligences, I would be surprised if you came up with this information, because it's just so complicated and different in every state. But go ahead and see what you come up with. But nonetheless, no matter what you hear from me, what you find on the internet, please, please, please see an elder law attorney who can make sure that you have the right rules and are following them, because the consequences of getting this wrong can be very large, can cost basically the money that you have. So please see an attorney on this. Exempt resources. So I said, what can be kept, what's countable, what are the standards, the 2,000 up to 157,000, depending on circumstances. What's not countable and what's exempt and what does not interfere with a Medicaid eligibility for a single or married couple is the home. The home is an exempt resource. Now, if you are a single person and your home's worth 2 million, that's a problem. But if it's worth 1 million, it's not. If you're a couple, and the spouse lives, the well spouse lives in the home, you can have a $10 million home. Of course, you're not likely going to be applying for Medicaid, but theoretically, you can have a house that's that valuable. You can have a single vehicle, not two. The second one is countable. All the personal property that you want, that you have, is allowed. A life insurance policy with a face value of less than $1,500, that's really a small face value. It's intended to help with burial. You can have an irrevocable prepaid burial or cremation plan, a burial plot or urn. There is an exemption for businesses if you rely on business. I'm not talking stocks and bonds. I'm talking about you have the family, business that provides you income. That can be exempt. A long-term care insurance partnership policy, the amounts that are paid under that increase how much money you can keep. And then this is the most useful tool that we have as elder law attorneys for couples, is what's called a single premium immediate annuity, also called a Medicaid compliant annuity. Now, that is a ton of information about Medicaid's rules. We'll keep going. There's still a little bit more before I give you some examples. So, how do you reduce countable resources? What do most people do? They just spend down all of their money. That is a way to reduce your countable resources, but that's not necessarily the best way. Think about a smart spend down. What's the best thing you can do with the money if you do need to spend down? You can buy exempt resources. You could invest in a larger home. You can pay off your mortgage. You can buy a new car if the old car needs to be, if you need to get a better car. You can buy other things that you need. You can't buy things for other people, though. Couple, you can buy things for yourselves. Single person, you can't buy things for third parties. You pay for legal services. And by the way, this should not come as a surprise. Elder law services for Medicaid eligibility are not inexpensive, because what we do is very complex and complicated and deal with a state agency to try to protect as much money that we can for you, for your benefit, for your family's benefit. It is not something that I would ever recommend anybody do on their own. I would never recommend that you go see any attorney that is not an expert in Medicaid. It's simply not a good formula for success. See an estate planning or elder law attorney with Medicaid expertise. So pay for legal services, pay for caregiving services, pay a family caregiver, but you can't just say, oh, my daughter's taken care of me for the last 5 years, I'm going to give her X amount of money. That's not allowed, not in the state of Washington. The payment has to be within 30 days of delivery of the services. So you can't pay somebody who's cared for you for years. Medicaid has a transfer of asset rule. Anything you do within 5 years, the state cares about. If you have transferred assets greater than 5 years from the time of your application, like at 61 months before your application, the state should not inquire about it. I said should not, because it is beyond the horizon for them to look at. Does the state sometimes say, tell me, what did you do with the money for that house you sold 6 years ago? Yes, they do. That's one of the reasons it gets complicated when we are working with the state agency with a Medicaid application. They don't always do the things that they should do and that the rules say. Sometimes they vary from that. If you give away assets, there is a penalty imposed at $12,842, 1 month penalty period for that amount of money. So for example, if you gave away $150,000 because you wanted to give away your money, you didn't want to spend it down, there'll be an 11.6, let's call it a 12-month penalty period. The thing about this penalty period ever since 2006 is that it doesn't start running until the person who is applying for Medicaid is otherwise eligible, but for the gift. So if you're going to give away money, you should definitely do so as a part of a Medicaid plan. If you do it without a Medicaid plan, it will cause problems. And if you give away money during this penalty period, there has to be a way for you to pay for your care. I mean, the person that you give the money to can't use it for your care. So again, that's why an elder law attorney is going to really help out. An elder law attorney will also tell you, you know what, not every transfer causes a penalty. As I mentioned, outside of the 5-year look-back window. Also, you can give away certain things like your house to a qualified beneficiary. Spouses, you can give anything to your spouse. That's not going to cause a penalty. A disabled child, you can give your house to your disabled child. You can give your house to a sibling who has an equity. In other words, they own the house with you. And there's a caregiver child transfer exemption that is very complicated. And you've got to dot your I's, cross your T's, but it sometimes is a very valuable tool to preserve the house, give it away to your caregiver child with no penalty. You can also give away assets to a trust that are for the sole benefit of a qualified beneficiary, such as a disabled child or any disabled person, as long as they're under the age of 65. If you're under the age of 65, you can give your assets to a trust, a D4A trust, for the benefit of the Medicaid client. Keep in mind that that trust has a payback to the state. You can also give away assets after you're on Medicaid, such as you can transfer your car, no penalty. So, talk about the CFC program. The CFC program is really interesting. It's like the COPES program. It pays for care in non-skilled nursing, but there's no transfer penalty. There's no penalty period. We already talked about the income standards for it. But the interesting thing about this is if you are in assisted living or an adult family home, for example, and they will accept Medicaid, which is a whole nother discussion. Will the facility take Medicaid? A lot of facilities won't until after a private pay period. But for the CFC, how it's used as a Medicaid planning tool is that, let's say you gave away that $150,000, that extra $150,000 the single person had, and there's a 12-month period of ineligibility. The CFC program will pay for your care. Remember I said you have to have a way to pay for your care? You do. The CFC program will pay for your care. If for any reason that you then needed to move from your assisted living or adult family home to a skilled nursing, CFC does not pay. Whomever you gave those assets to needs to return 100% of those assets. That gift should not have been spent because they might have to give it back to you. Because if they don't give it back to you, Medicaid may pay for your care under a hardship exemption, but they will go after, or the rules allow them to, whether or not they will is another question, the gift recipient for 150% of the cost of your care. So it's a really bad result if ever you gave a gift and the person doesn't give it back when they needed to. So once you're on Medicaid, then that Medicaid beneficiary gets all of $105.78 a month to keep for whatever their personal needs are, for their supplies, for their haircuts, for whatever it may be. The rest of their money goes to the facility. And the Medicaid beneficiary must stay under $2,000 in their bank account, which is not hard because all the money that comes in goes back out to the facility except for their $105. For a married couple, the community spouse, and this is after the ill spouse is on Medicaid, we've done the application, ill spouse is on Medicaid. So in order for that to have happened, they needed to be within resource limits at the time of the application. Once the ill spouse is on Medicaid, we want to transfer all the assets over to the well spouse, the community spouse. And we want to do that before the 1-year eligibility review. We also want to do that right away because having all the assets in the name of the community spouse avoids the state having any right to those assets. Because the state has something called Medicaid estate recovery. The state of Washington can say, all right, Medicaid beneficiary, you have died. Let's say you were a single person and you still had your house. Well, guess who has the right to that house, at least to the extent of benefits paid? The state does. And that comes as a big surprise for the family of the single person who was a Medicaid beneficiary because their family member was on Medicaid. They probably didn't see an attorney who said, you know, who's going to get the house? It's not going to be you kids, it's going to be the state. So even if you have a loved one who is on Medicaid, especially if you have not worked with an elder law attorney, see one, because we can take steps to make sure the state does not get the house. For a married person, it's pretty easy to avoid estate recovery. How? As I mentioned just a moment ago, transfer all the assets to the well spouse, to the community spouse. In the state of Washington, we are a community property state, yes, but we can also say everything is a separate property of one spouse. And in this situation, we would say through a separate property agreement and transfer, everything is owned by the community spouse. Well spouse owns nothing. As a result of doing that, then the state has no right to recovery. So I had mentioned a single person, they're going to lose their house because they haven't seen an attorney. What can be done? Let's talk about that. But before we get there, we had talked about the basic estate planning documents. As an elder law attorney, I don't want to just see basic estate planning documents. I know you think your estate is simple. All you need is a simple will. All of us, I think when we say simple, and I say it all the time, it's like, don't make things more complex than they need to be. But when we're talking about Medicaid, qualification, and protecting assets, they need to be a little bit more complicated than if we're not concerned about those results. So let's revisit very quickly what estate planning basics are: durable powers of attorney, a will, and a trust. What I want you to tuck away in your mind, especially if you are married, is that if you have a revocable living trust, that is problematic. Only a will can protect assets for the surviving spouse against long-term care costs. I even in this slide put the citation to the Washington Administrative Code if you'd like to look it up. And if you do, be prepared for a very convoluted, ugly looking provision. 182.516.0130. We want to see estate planning with asset protection for long-term care. What does that look like? The durable power of attorney for finances is critical. In that document, we want to see the authority for the attorney in fact, who might not be the spouse. Maybe they've lost capacity, but fortunately they got these documents in place before the dementia overtook their ability to make decisions. We want to see in the durable power of attorney for finances the authority to revoke a community property agreement and to enter into a separate property agreement. Remember what I said, that to avoid the state getting any of the couple's assets when the Medicaid spouse dies, we can do that if we've put everything in the community spouse's name. How do we do that? Especially when the Medicaid spouse has lost capacity. We do that through a durable power of attorney that grants authority to transfer the assets. So not having that one provision in your durable power of attorney because you didn't go to an elder law attorney, you went to a general practitioner or an estate planning attorney who might be very good. They don't practice Medicaid. You might not have the authority to do that. And if that's the case, then 1/2 of your assets or more are going to be subject to the Washington estate recovery because of lacking this one authority in your power of attorney. So how would you know that? You would not. And I don't expect anybody listening today or re-listening to, no, hey, I got to do this. Again, my message is see an elder law attorney. Another provision that's critically important in your durable power of attorney for finances is gifting authority. Now, gifting authority typically says up to the amount of the annual exclusion gifting. What that is that's the amount you can gift without having to mention it to the IRS. Many of us remember that when it was $10,000, it was $10,000 for years. Well, because of inflation, where it's at this year in 2025 is $19,000. So if you were thinking it's 10 and you've got to give away only 10, no, you can give away 19. That limited amount, though, of gifting authority is too restrictive when it comes to an elder law attorney doing a Medicaid plan to protect assets, especially for a single person, which I will show you an example of. So the durable power of attorney isn't as important when the person who needs care has capacity and they can do all these things, but that's not good planning. You've got a plan for the person who needs care. They need care because of dementia. So we need to have somebody else act as that person would if they could. So we need good durable powers of attorney for finances with the ability to revoke a community property agreement and make a separate property agreement, and gifting authority that could be up to all of their assets, even if that means a gift tax return needs to be filed with the federal government. There is no gift tax that's going to be imposed. So is it a hassle to file a gift tax return? It's fairly simple. Your accountant can do that for you. Especially, is it worth it? You'll see the example that I'm going to give you of $240,000 saved. That's worth doing a gift tax return for $240,000. Now, focusing in on the dispositive documents, those are your wills and your revocable living trusts. A will should contain a supplemental needs trust for the spouse because the state of Washington will honor a will that has a supplemental needs trust in it to protect assets for the surviving spouse. A revocable living trust, even if it has the very same language in it that I, provide assets to a supplemental needs trust, discretionary standard for the benefit of my surviving spouse, it's worthless when it comes to Medicaid long-term care protection because the state of Washington will not honor, will not respect a trust created by a revocable living trust. So let's say you listen to Susie Orman or some other financial planner, or somebody says, revocable living trusts are the way to go because you avoid probate. And if it's done right, you will avoid probate. But what's the cost of avoiding probate because you have an RLT, or revocable living trust? It could be 50% to 100% of the couple's estate. Not a good result. So who is going to be recommending a revocable living trust? Don't get me wrong, at ELG Estate Planning, we often do, but we're not trying to protect against long-term care costs. There's another reason for it, and it's not long-term care cost protection, because if our client's situation is long-term care cost protection, we will recommend a will with a supplemental needs trust in it. And if your estate planning elder law attorney doesn't follow that, you might want to seek out the services of a different elder law attorney. So a revocable living trust, this is just to explain what it is, and just basically to point out there's no asset protection against long-term care costs for the surviving spouse. A revocable living trust in the state of Washington is even more problematic because if your house is in it, it just moved from being a non-countable asset to a countable asset. So we have to basically undo the trust, get the house out of it, which fortunately it is a revocable living trust, so we can fix the problem. But it's best not to have the problem to start with. All right, here's an example of a couple. They each have a will with an asset protection supplemental needs trust. Sometimes I say supplemental needs trust, sometimes I say asset protection trust, sometimes I put it all together and say asset protection supplemental needs trust. That's a mouthful. I mean the same thing. In our example here, let's take Fred and Betty. Betty has Alzheimer's and Fred takes care of her at their home. Their house is a modest house, $300,000. They have a retirement investment savings of $700,000. Together, Fred and Betty have $1 million, and I can tell you they don't feel like millionaires. But they do, they have $1 million. So in Washington, then each spouse has a 1/2 interest. So Fred owns $500,000 and Betty owns $500,000. So what happens then when, with this asset protection trust with $1 million estate, let's have somebody die, Fred is going to die first. Remember, Fred is the caregiver spouse. When he dies, Betty can't stay home safely. She's going to need to move to facility-based care. So on the death of Fred, his 1/2, his $500,000 funnels through probate into this trust for Betty. Betty still has her own 1/2 or her $500,000. What's important to understand is the $500,000 that was Fred's is in this trust for Betty. The state of Washington will honor that asset protection. They will not count that $500,000 as being Betty's money. It will not interfere with Medicaid. We know that Betty is going to need long-term care in this situation, given her Alzheimer's. So what's she going to do with her $500,000? Actually, not her. She has Alzheimer's. It's going to be her attorney. In fact, probably use that money to pay for private pay at a care facility for 2 or 3 years. If she wanted to do more, if her attorney, in fact, were to reach out to us, we have other Medicaid strategies to preserve more of that. But there are strategies. But the key point here is that this couple protected 1/2 of their estate, $500,000, simply because they saw an elder law attorney that understood Medicaid's rules and what the estate planning documents need to be to protect that money. That money is there for Betty's lifetime to take care of her in any way that she needs it. And on her death, it will pay where Fred said it would. Let's say the couple has 2 children, it will go down to the 2 children. Sometimes we know that somebody is going to be dying. Same scenario, except for Fred is getting sick and he goes to the hospital. Betty, not Betty, her attorney, in fact, is going to contact us. We prepared the estate plan and they said, Fred's in the hospital. We want to deliver all the assets to him. We can do that. Remember, we can do a separate property agreement. We can deliver all the assets. to Fred, such that when Fred dies, he owns not half, but 100% of the assets. And through the probate of his estate and through his will, 100% of the assets, or $1 million, everything this couple had, goes into this asset protection trust for Betty. Betty is immediately eligible for Medicaid. And let's say Betty's care is care that needs to be in a skilled nursing facility. Skilled nursing facilities typically do not have a private pay period. She's immediately eligible and the state is paying for her care. The $1 million doesn't count against her. The $1 million will go to the kids on her death, but it is there to provide any extras that she needs. On the other hand, let's say she's still in assisted living or will be in memory care. The money, that $1 million in the trust, will be used to take care of her. That's what the trust says, but there will be money left at the end of her life to go to the kids. None of this money is subject to estate recovery or a lien when she dies, even if she's been on Medicaid for years. This is the most powerful estate planning tool that an elder law attorney has in the state of Washington. So we're going to switch gears. We have time to go through strategies, Medicaid strategies, when somebody hasn't died. What I just talked about is what happens when one of the spouses dies. So now we're going to talk about, okay, we have a person, a single person or a married person, and they need long-term care. And they want to avoid the financial trap of spending down all their money, everything they worked for throughout their lifetime. They want to avoid the result of being impoverished at the end of their life from their long-term care costs. And we can help them do that. And this is how. Single person. Let's say that the person who we're talking about is at an adult family home or is going to move to an adult family home. The cost of care in this adult family home is $6,000 per month, not per moth. Just caught that. The person's income is $3,000 per month. The cost of care deficit, what they're short, is $3,000 per month. Let's say the single person has a home and it's worth $320,000, and they have a bank account or other investments worth $60,000. Remember what Medicaid says? You can only have $2,000 in that bank account. What are we going to do? In this situation, the recommended plan is, let's use the money that we need to use to get that house ready for sale. Let's use $20,000 to buy a better car because their car could be improved on. Let's use $5,000 to buy a prepaid irrevocable burial plan, and let's use the rest of that money to pay for their care and to pay for the elder law attorney services for the Medicaid plan. Once we have spent down that $60,000 in this smart spend down strategy, the client has $2,000 we apply for, and she is approved for Medicaid. She is on Medicaid. Here is the next and very interesting step of how we can avoid the state ending up with the house. How we do that is basically we're going to sell the house and we're going to give proceeds. When a person is on Medicaid, this is when the strategy works. We take the house, we sell it, it nets $300,000 in the proceeds. She will gift $240,000 and keep $60,000. Why are we having her keep money? Remember, if you give away assets, the state imposes a penalty period for giving away the assets. And in this case, she gave away $240,000. That divided by the penalty divisor of 12,842 results in a penalty period of 18.69 months. Let's round it up to 19. During this 19-month period of ineligibility, she uses that $60,000 that she kept to continue to pay the same adult family home where she has been living and will continue to live. 19 months times a 3,000 month deficit is $57,000. So very shortly after she's got herself through that 19-month period of ineligibility, we reapplied for Medicaid. She is accepted back on the program. Medicaid pays for her care. What is the result? The result is $240,000 actual dollars was preserved of this person's money for her family. And that $20,000 car is also gifted as well. So basically $260,000. The majority of this person's assets by far are preserved for her family, which is what her wishes are. The state has no right to recovery. Now, sometimes people have a problem with this strategy, and I say, absolutely, you have to be comfortable with it. If you want to spend down all your money, that is your right. My job, though, is to make sure you know what your options are so that you're not doing it out of not understanding, but because you want to spend all your money. Let's talk about people who are married. So we don't have anybody dying yet. Brendan hasn't died, etc. We have a married couple, they are alive. I didn't use the same language, Fred and Betty, because we have different fact pattern here. So we have a married couple. Let's say they have an $800,000 estate. It could be $1 million. The house could be worth $600,000. It doesn't make much difference. I just changed the numbers so that we wouldn't confuse it with what happens when somebody dies, that scenario. So we have a married couple. Their house is worth $400,000. They have bank accounts, investments, countable resources of $400,000. Medicaid says in order for the Medicaid spouse to be eligible, well, we don't count your house. So that's why it doesn't matter if the house is 400, 600, 800, doesn't matter. But the state looks at, well, how much money do you have? What's that? You have a $400,000 bank account. You can't have that much money. Even though the ill spouse is in a skilled nursing facility, the maximum that can be kept for the well spouse, the community spouse, is $157,920. So you're over-resourced by $242,000. What are we going to do? Most people spend down that money. That's what I hope to prevent. That's what I hope that this information will make a difference to your life or to the life of somebody you know that might be in this situation. Because what we can do is we can take that extra $242,000 and buy a Medicaid compliant annuity. In the state of Washington, the annuity must have a term of 5 years unless the spouse's life expectancy is less, but let's go with the 5 years. We have the well spouse, the community spouse, same thing. Buy this annuity with $242,000. It will pay back to them month after month after month for the next 5 years, for the next 60 months at basically $4,000 a month. They get all of their money back. In other words, there is no Medicaid spend down at all for a married couple, even if they have $800,000 or $1 million or what the value of their estate. Now, at some point in time, the couple has so much liquidity, so much money in bank accounts that it makes no sense to do a Medicaid plan. But for many, many clients who have an estate level of this amount, it makes a lot of sense. And it makes sure that the community spouse is never impoverished, which is really important to the couple and to your elder law attorney as well. What if the community spouse dies before the Medicaid spouse? Well, if they didn't have proper planning, sometimes a nursing home will do an application and an elder law attorney wasn't involved. And because the couple qualifies, they don't have so much money that they don't qualify. But if the right estate planning documents are not in place and the community spouse dies first, typically their I love you will says everything goes to the Medicaid spouse. They're going to be bumped. They're going to inherit the assets outright and not in a protective trust. They are going to be bumped off of Medicaid until their money is spent down. They might still have a house, and then the house is going to be the state's. Bad result. What is a better result? Well, with the right estate planning, this couple will have seen an elder law attorney. We would have prepared a will with asset protection trusts. And then if the community spouse dies, and remember, they have everything in their name because everything was put in their name to avoid the state having any right to it. When the community spouse dies before the Medicaid spouse, before the ill spouse, all of the assets then go through the will, through probate, into the asset protection supplemental needs trust for the Medicaid spouse. Their benefits are preserved. The ill spouse is not bumped off of Medicaid. They will be on Medicaid, and at the end of their life, the assets in that trust are not subject to Washington's estate recovery. They will go to the remainder beneficiaries, for example, the kids. We preserved all of the assets again in this scenario. So Medicaid is not an impoverishment program for married couples if there is the right estate planning in place done by a qualified Medicaid elder law attorney. So we are 4 minutes at the end of the hour. I want to thank you so much for sticking with me throughout that pretty complicated discussion. If you have any questions, feel free to put them in the chat right now. And otherwise, you can give us a call. We're at 509-468-0551. We have our website, elgwa.com. We also have a YouTube channel with lots of information. This will be posted to the YouTube channel. If you see it on YouTube, please feel free to give it a thumbs up, subscribe, share it with anyone that you think might benefit from the information provided today. So again, thank you for being with me today, and I hope you found this helpful, and we look forward to talking with you.